Welcome to Krishna Shorthand Institute. Get ready for dictation. Start. At the very outset, it was submitted on behalf of the appellant that the corporation had no grievance against the award as was made by the Labour Court on 23rd February 2025 and that the corporation was ready and willing to reinstate the respondent and to pay 50% of the salary last drawn by him. The corporation was, however, aggrieved by the subsequent award passed by the Labour Court after remand, whereby the Labour Court altered its earlier directions after coming to a finding that the respondent was entitled to full back wages and not 50% as had been directed earlier. It was sought to be urged that after coming to a finding on the basis of the evidence of the respondent himself that during the period of termination of his services he was engaged in agriculture and that he was receiving certain amounts therefrom, it was not open to the Labour Court to observe that gainful employment would not include such income from agriculture. It was urged that income from any source, whether from employment in an establishment or from self-employment, would have to be treated as income for the purposes of deciding whether the respondent would be entitled to receive full back wages. It was urged that both the tribunal and the High Court erred in taking a view to the contrary, and the orders passed on the basis thereof were liable to be set aside. On behalf of the respondent, that stand taken before the Labour Court and the High Court was reiterated, and it was contended that engaging in agricultural work would not amount to being gainfully employed, and hence the orders passed by the tribunal as affirmed by the High Court for payment of full back wages to the respondent did not call for any interference. We have carefully considered the submissions made on behalf of the respective parties in the backdrop of the facts of the case, since the finding on the issue as to whether the domestic inquiry had been fairly and properly held had been decided in favor of the respondent and had not been challenged by the appellant. The only issue which was remitted by the High Court to the tribunal was whether the respondent would be entitled to full back wages from the date of his dismissal till the date of the award with continuity of service and consequential benefits. On the said question, we are unable to accept the reasoning of the Labour Court that the income received by the respondent from agricultural pursuits could not be equated with income from gainful employment in any establishment. In our view, gainful employment would also include self-employment wherefrom income is generated. Income either from employment in an establishment or from self-employment merely differentiates the sources from which income is generated, the end use being the same. Since the respondent was earning some amount from his agricultural pursuits to maintain himself, the Labour Court was not justified in holding that merely because the respondent was receiving agricultural income, he could not be treated to be engaged in gainful employment. The provisions of the Act of 1950 make it clear that it had a separate and independent identity of its own. It is not a part of the government and therefore the ownership. The appellant presented no objection to the original Labour Court award from February 23, 2025, expressing willingness to reinstate the respondent with 50% of previous salary. Their grievance stems from the subsequent modified ruling granting full back wages instead. The central dispute concerns as to whether agricultural income constitutes gainful employment. Stop.